So my friends, so we still have these benefits under SB 95 or Senate Bill 95. In short, you call this the CSPSL or the California Supplemental Paid Sick Leave. It took effect in March 29 and it will sunset on September 30, 2021. And so always remember, especially those payroll, because Elizabeth and Elma normally coordinates with payroll if they are informed by the infection control preventionist or by the DSD that they have employees that are confirmed to have been exposed or COVID positive. So what they do, they coordinate. So always remember, this will end on September 30. But this is retroactive. Well, it took effect on March 29. We already know this, effective January 1, 2021. And this is simply a review, applies to all employers with 26 or more employees. And they're entitled up to 80 hours of paid sick leave. So in other words, when you place them on isolation or quarantine, it does not automatically mean that they should be given 80 hours. It depends on the number of days that they are off work as scheduled, pay them that. I'm pretty sure they're going to argue with you. How come I will not be paid 10 straight days? It is only when they're scheduled to work because those are the days that they lost wages, presumptively because as scheduled. But it would work for their benefit because there are 7 qualifying conditions or eligibility. So if, for example, if they were placed on quarantine or isolation and they were scheduled to work only for 5 days and you pay 5 days, so basically that would be 40 hours. So they still have another 40 hours remaining, right? So if for some reasons one of their family members in the same household has a COVID case, okay, then since they still have a remaining balance of 40 hours, then they can use that. And it must be paid prior to other paid time of benefits. So in other words, you cannot force them to take their paid sick leave, accrued paid sick leave, the company's paid sick leave. I'm talking about that. Or their accrued vacation benefits. No, CSPSL will come in first before any of those 2 leaves because that is at their option whether they want to take it or not. You see? Now, if they took it ahead of the CSPSL benefits, for some reasons, you inadvertently made a mistake or perhaps you forced them to take that first, my friends, you have to offset it. You have to credit it back to them. It has to be reinstated. Okay? But reinstatement, you don't have to pay them back. You just reinstate. So for example, if I took 24 hours before you paid me your CSPSL benefits, how will you rectify? Paid me my CSPL benefits, and then the accrued paid sick leave that I took of 24 hours will again be reinstated and it will appear in my pay stub because that is a requirement that should appear in your pay stub. And it must include the available time on employee pay stubs. Remember, if you take the CSPSL benefits, if you qualify, there must be an area in your pay stub that should appear how many hours still remaining and how many hours you took. Now, if you did not qualify under CSPSL benefits, or say for example, you never had any of those qualifying conditions, which I'm going to discuss shortly later, it does not appear there. Now, appearing in the pay stub is a requirement under the law, especially under PAGA, Private Attorney General's Act. My friends, perhaps you do not know this. But this is now the trend. And then we know that Mr. David, the governing board, Maribeth and I, we are very much worried regarding this PAGA. And the pay stub, there are 12 or 13 items required under the law that must appear. Absence of one, Jim Bolt said, we will be in serious trouble. And one of them is the CSPSL benefits. And other than that, an employee can go to the labor commissioner. They will say, you know what, I was not paid for my CSPSL benefits. But if you have this in the pay stub, plain and simple, you can submit this as an evidence. And the CSPSL benefits, we already know this, discussed this, it must be posted. Again, it will sunset on September 30. And I don't have to go through this one by one. This is just a review. So these are all the 7 qualifying conditions. If you see 6 here, because What I did in number 3, I included the other qualifying conditions because they are germane, they are related. So if you place an employee on isolation or in quarantine, okay, in accordance with the federal, state, or local guidelines issued by CDC or CDPH, then pay. Or if the doctor of this employee advised the employee to go on self-quarantine, pay. If an employee will attend an appointment to receive a COVID vaccine, okay, or if he has side effect, and it is more than mild, it is moderate, and worse, severe, if they are out of work, you have to pay. Remember, the payment is regular wages. Regular wages. So if an employee receives on a particular day, okay, $150, okay, then $150 times the number of days that they were off work as scheduled. Okay. Now, if they have symptoms and they would seek medical diagnosis, or this one, employee is caring for a family member. Now, when I say family member, my friends, it's not only up to your father and mother. It includes grandparents and includes parents-in-law. And it includes not only nephews and nieces, but including grandchildren, but living in the same household. You see, you are entitled, an employee is entitled to that. And of course, lastly, caring for a child whose child or child provided is closed for COVID-19. Now, there are times where we have to, I'm pretty sure you know where we come in, right? We pay 2/3, right? There are times, instances where we pay 2/3. That's why, the DSD and ICP, I hope you understand. If Elizabeth and Elma contacts you, or you inform us that there is an employee that is COVID positive, you have to coordinate with our office. Why? Because we are going to determine whether it's facility acquired or community acquired. Because we have to comply with CSPSL benefits as well as the exclusionary pay, as well as the workers' comp. Remember, work-related injury or illness, that is facility acquired, they're entitled to workers' comp benefits and in the exclusionary pay under AB 685, which I'm going to discuss shortly later. So if it's facility acquired, what Elizabeth and Elma does is they request you, okay, certain information, payroll information, because we kick in the 2/3. And to make it whole, then the facility will pay the CSPSL benefits 1/3 and equals to 100%. Right? Now, do I have to give my employees any other benefits? The answer is yes. So if you have, on top of the CSPSL, you have accrued paid sick leave, the employee and vacation benefits, give it to them. Can you force it to them? No, you cannot. That is their right. But if you see here, can be forced as to paid sick leave, my friends, let's not adopt this, okay? Let's not. But this came from a law firm during the presentation, but I did not ask any questions anymore. No, CSPSL benefits comes first before they can avail vacation or paid sick leave. But do not force them to use this. Now, say for example, they already consume their CSPSL benefits or their sick leave or the vacation benefits and they are still off work. Perhaps the condition is more or less serious. It's not only 10 days, right? Remember, at the end of the 10 days, you terminate provided that they are symptoms-free without using any fever-reducing medication. So if their symptoms is still present, so they already exhausted all of this, my friends, they can apply for SDI, State Disability Income, and they have to go to EDD, right? But when we get that notice and which we have to respond within 2 calendar days, you have to put there the vacation benefits and the sick leave benefits if that you provided, because that will be factored in the payment for the SDI. Okay? So you have to be very mindful when you get that notice of disability application by that employee. Now, do you have to pay employees when they quarantine? We already know that, right? Under CSPSL benefits. And under the ETS, that's what you call exclusion pay. Exclusion pay. And our office, we have already construed this in coordination with, our workers' comp insurance carrier, okay, that the exclusion pay pertains to the tutors that we are paying. Okay? Provided that it is ward-related exposure. In other words, it's facility acquired. But if it is not community acquired, there is no such thing as exclusion pay. There is no such thing as workers' comp, temporary disability pay. Okay? But they get 100% of the CSPSL benefits. Okay. Do you have to give your employee a leave of absence for COVID-19 issue, my friends? Yes. You don't want them to be in your building and force them to work if they have COVID-19. So these are just the different laws available that an employee can avail to go out on leave. When I say out on leave, these are unpaid. And this is job protected. FMLA and CFRA, they are job protected and they are entitled up to 12 weeks, right? Due to their serious health condition. See? FFCRA, we know that the Family First Coronavirus Response Act. And of course, your own COVID-19 mitigation protocols that you have. Now you have two, the CPP and the one that you have for your residents that has been approved by the Department of Public Health. So you have to provide reasonable accommodation also. If an employee has medical or religious reasons, and also under the American with Disabilities Act. So, but my friends, if you encounter this kind of situation, please refer it to our office, either to Elizabeth, to Elma, or myself. Okay? Do you still have to conduct contact tracing? The answer is definitely yes. Again, the most restrictive is CDPH. And this will just show you, okay, the 15 minutes of contact. Okay? Direct contact. It is cumulative within a 24 hours period, less than 6 feet apart. No employee names. I will discuss that. This is an area where, most of you doesn't know. We are talking now of confidentiality under the emergency temporary standards. 685. So, under this particular state law, okay, which actually was signed in September 17 of 2010, which took effect this year, January 1 of 2020. And this law will expire on January 1 of 2023. So, required after receiving notice of a positive test result. What does it mean? Provide notice to all employees who were at the same work site with the positive employee within the infectious period, meaning within the last 48 hours or 2 days. Okay? This notice is a requirement. So now you're now telling me, Joey, then we're breaching confidentiality. That we have a confirmed positive employee, and now the law requires us to notify the employees that we have an employee that is tested positive. My friends, I will send you the notice. The notice does not state to the effect who are these COVID positive employees. The law simply requires that you have to inform that we have an employee, X, perhaps if you want to, is tested COVID positive. Okay? Now, the exception is, for purposes of divulging the name of the COVID positive employee, is when you do your contact tracing. Because how could you do your contact tracing objectively if you don't tell those people that had close contact who that person is, right? So you have to tell the name. That is the exception. But in general, the law requires, there is a template, which I'm going to send it to you. Okay? See, employee notification of possible exposure to COVID-19. You see? I will send this to you. So that if there is confirmed COVID positive, employee. Okay? Inform. General. Okay? Now, again, back to your condition again your mind. This only pertains to employees. Okay? It has nothing to do with residents. Let's move forward. SB 1159, Notice to Workers' Comp Carrier. This is an area that you have to thank our office in general. Especially to Elma and Elizabeth. Don't you know that every time you report to us your COVID cases of your employees, whether facility acquired or community acquired. That's why if you think that it is just simply administrative or mechanical on your part, okay, you report to Elizabeth, to Elma. No, my friends, we don't just record it for purposes of recording or simply as part of our every Friday, what's this Zoom meeting with Mr. David, etc. No, my friends, this law, we have to report it to our carrier. There is a reporting requirement. You see here, the penalty if we fail to report, $10,000. You see? So if your OSHA will come in, and if they will want to find out whether we are in compliance with SB 1159, my friends, you can sleep well. Because from the very beginning, when this law took effect, okay, September of last year, we already reported all of your COVID positive cases, employees, both facility acquired and community acquired, to our carrier Sedwick. Now, reporting to Sedwick, my friends, to our workers' comp carrier, do not worry, administrator, because that is not a claim where the employee automatically will be entitled to benefits, where your premium will be affected. It will not appear when we request a copy of the loss runs or when Dave Lipa is going to renew your workers' comp policy. It will not reflect there. So don't worry about it. So, what the law states, when we report, it must be reported within 3 business days. Required if the positive case was at work in the last 14 days. Okay? So, regardless, community facility, we have to report it. Okay, now, of course, ETS says you have to notify your local health department and call OSHA. Local health department, no issue. You have your CDPH, AFLs, you have to report, right? How about to call OSHA? My friends, you don't report to call OSHA. You only report to call OSHA when it is serious injury or illness. And who reports it? Our office. So that's why it is very important. This is time sensitive. When management wound up or found out that one of your employees or any of your employees ended up in the hospital, or if not in the hospital, perhaps he is hard-headed, he just wants to stay at home with a serious illness as a result of the COVID, please immediately report it to Elma and Elizabeth. Why? Because within 8 hours upon knowledge, we have to call OSHA reporting center. If we fail to report, you know how much? $5,000. Did you know that? So that's very important. So our role is very vital. We are very relevant in this pandemic. We are taking this off from you so that you can concentrate with other matters in your building. Okay? Now let's move forward. These are scenarios. Okay? Your employee won't come back to work because of medical issues. Perhaps you might have encountered this. DSD, administrators. Due to medical reasons. So of course, they cannot just come out here, you know what, I cannot return to work because of, the COVID, etc. Whatever it is, medical related. Perhaps due to pre-existing conditions, I cannot come to work. I'm an immunocompromised. I might end up with the COVID. Ask the employee medical certification. Ask. In the absence of that, no. Okay, now I'm reminded. The CSPSL benefits is not automatic. There is a form, they have to fill it up, and they have to support with a self-writing attestation that they had COVID or whatever it is. Okay? Any documents, it must be attached. Do not take their word. So, in this instance, if you have the medical certification, now you review if he's entitled to any leaves of absences. So, there are type of leave of absences, right? 2 types. One is benefit entitlement. Benefit meaning money, money, money. Leave entitlement meaning job protection. See, if they qualify under FMLA, qualify under CIFRA, that is leave entitlement, job protected and paid. Benefit entitlement, are they entitled to CSPSL? Are they entitled to their accrued paid sick leave? Are they entitled, or do they have still accrued vacation benefits? Now, if as a result of the medical certification, you go through the motion is the interactive discussion. it is an option to provide them reasonable accommodation, right? So you can tell them, look, don't worry, okay? Because protected under the American with the Disabilities Act and the ETS and other relevant laws. Don't worry, we can accommodate you based on your medical certification, provided that there is a release coming from the doctor. We can provide you light duty. Okay? Don't worry. Now, reasonable accommodation can include remote work, but that is at the discretion of the administrator. You can just easily, hey, you know what? I can still work at home. You cannot force your employer to give you that privilege. It's up to the administrator whether you can work at home. Already discussed paid sick vacation time or unpaid personal sick leave. Now, what if your employee doesn't feel comfortable coming back to work? Yeah, perhaps you might ended up with this kind of situation, right? Uncomfortable, simply uncomfortable. My friends, don't be negative to your employees. This is a mental issue. Mental issue. A mental issue is protected under the American with Disabilities Act, right? Physical and mental disability. I don't know if you're watching the Olympic Games. I watch Olympic Games. Simone Biles, the gymnast, refused to participate because of mental health issue. So you cannot force them. Okay? So what you do, you must show your compassion to them. See? By the way, we won, the gymnast. The one who took over is Sunli. Sunima Lee. I know already, Sunima. But you call it in short, Sunli. All time, okay? Gymnast. He's a Hmong. Where is Sumoa? Sumoa, we should celebrate. Won. Swimming, we also won swimming. Bobby Fick, gold medal, 800 meters. We also won 100 meters, right? This is just to deviate a little. Okay, very important. Watch Olympics so that you can rest your mind. Then discuss the reasons for concern. You go to the interactive discussion. Why do you feel uncomfortable? So you remind them, assure them, don't worry of your safety, the sanitation procedures, we have all of this in place. And then you can ask the employee for any inputs. How we could welcome you, how we could accommodate you. Now, if the employee still refuse, they're still uncomfortable, remember, that is their right. You cannot force them to come to work, right? Then see if they can avail any of the leaves of absences under state or federal law. Okay? But most of these leave of absences are unpaid, right? Now, can you terminate their services? We will go into that. Now, this one, not only uncomfortable, refuse to come to work. No, you see? This image, no, I don't want to come to work. So what are you going to do, right? Again, interactive discussion. Be compassionate. Why do you refuse to come to work? Is there something that bothers you? Okay? But be careful, the medical, do not go into details. You might end up with, a form of discrimination. And then see if you can provide reasonable accommodation at home, work at home, okay, or perhaps in the building. Now, if they refuse to work without legally protected basis, that is where we come in. You see, they are deemed to have been voluntarily resigned. You see? Refuse to come to work. Okay, we understand, but we'll try to do our best. Please come to work. But my friends, there are people who are irrational. More so if they go into the political side of it. You see, they refuse to come to work. Well, you can tell them, look, you can only be excused if it is due to medical or religious reasons. Under EEOC and DFEH guidelines, those are the only two protected categories that they are protected. That you cannot discriminate. Other than that, you are well and dandy. It's just that you don't want to come to work, refuse, or sorry, you're deemed to voluntarily resign. Are we discriminating? The answer is no, because there are only two protected categories. Okay? But don't do that outrightly. Give them the opportunity and, more important, documentation. Now, your employee would rather collect unemployment benefits. My friends, Elizabeth and I and Elma, we are involved in your unemployment benefits. And most of them, a sizable portion are due to reason for separation, due to COVID-19. You have to be very careful. Remember, if you disregard your unemployment insurance claim benefits by your employee, and then they ended up getting UI benefits, it will affect your state payroll tax. And you have 10 calendar days. Calendar days, this is time sensitive to attend to. So if there is reason for separation, COVID-19, and if you know it has nothing to do with COVID-19, this is a fraudulent claim, you really have to fight it hard. Okay? Now, that's why in advance you have to inform them. Okay? That you will report their refusal to work to the EDD. Because there are people, they don't want to work. I will apply for unemployment. Okay? Now, you will inform them that you are not entitled to. Okay? Remind employees that the refusal to work without a valid reason constitutes a resignation and they will be replaced. See? They would rather end up with unemployment. You refuse to work and they will use COVID-19? My friends, that is considered to be fraudulent. See? Discuss with employee to investigate the basis of the false statement. It is false statement, what you indicated. Warn employee about EDD fraud and ask the employee to revise the claim. So, DSD, you can call the employee, look, I got here a notice of unemployment. You applied for unemployment due to COVID-19. But based on our records, you did not get any COVID-19. It's just that you refused to work. Now, let me tell you in advance that this is considered to be a fraudulent claim. And let me warn you that we are going to call the hotline. You better change, the reason for your separation. So, what would happen here? You see here, file with EDD. Fraud hotline, 1-800-229. See? Or you can even fax the information. That is our option. Now, what if an employee refuses to wear a mask? So you don't immediately, trigger any disciplinary action or retaliation. And we know, okay, those vaccinated and unvaccinated, you really have to go through the motion. So remember, if they refuse to wear a mask, accommodate medical issues. Perhaps this might have medical issues. But it must be supported by a medical certification. So, if they refuse to wear masks, perhaps in the alternative, provide face shields. Or perhaps remote work, or just place them on unpaid medical leave. But remind employees of the OSHA mandate, right? If you're unvaccinated, indoor, you have to wear your face mask. Put employee on unpaid suspension and inform him that he can return if he complies with the mask mandate. See? Unvaccinated, but insists of not wearing a mask, you can place this employee on unpaid suspension. Meaning administrative leave, right? But unpaid. Unpaid leave until masks are no longer required or terminate for further instructions. No more pandemic. Okay, you can return now. But you can place them on unpaid suspension. So, already discussed this. Can I mandate vaccinations? It is already clear as a water, clear as the blue sky, that we can mandate. EOC and DFEH, very consistent, and there is already a ruling by a federal Supreme Court, okay, the U.S. Methodist Hospital in Houston, Texas, where those employees filed a case because the hospital say, no, you have to get vaccinated, otherwise we will not allow you to work. We are going to terminate your services. And they said it's a violation of their rights. My friends, the court said no. Because of the pandemic. Because of EEOC guidelines. We can mandate. But you don't indiscriminately use this. You have to evaluate. You have to run it, of course, with the governing board. And of course, my immediate supervisor. Because we provide consultancy services in this area. So you go to this motion. Because if you enforce to current employees, see to it, you have to balance. Perhaps you might end up shortage in staffing, which is gold nowadays. But can you mandate this to those applicants, newly hired employees? I would say so. Not unless you are desperate to have employees to work. But if you have the luxury, the liberty of not hiring them because they refuse to take the vaccine, that is not discriminatory. You can say, look, our policy is, and which you already have, amended as part of our employee handbook. Gonsi already sent it to you. You see? You say, we have a policy. We mandate everyone to take vaccine. So, If you refuse to take the vaccine within 5 days or 10 days upon hire, we are going to withdraw our offer of employment. But again, evaluate, run with your GB and with my boss. Okay? What if my employee refuses to be vaccinated? See? Of course, do not terminate immediately. Interactive discussion. Don't be aggressive. Be compassionate. Listen to their side. And we know nowadays, they must take the vaccine, right? But be rational. Do not argue. Do not quarrel. Do not verbally abuse. Do not ostracize. Do not discriminate. Do not make announcement to everyone and destroy, the reputation of this person. My friends, that is considered to be discriminatory. You are now creating a hostile work environment to a person who is unvaccinated. So just deal this employee for who he or she is if he refuses. But do not permeate stories. Hard-headed. He has an attitude. Blah, 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 blah. Don't do that. Okay? You might end up with discrimination, or retaliation, or harassment. Perhaps you might want to consider a temporary leave of absence. You can do that, but do not terminate. Remind employees that they may not ask others about their medical choices. You see? This is confidential. So you tell the employees, hey, don't be nosy, don't be intrusive. Why he's not taking the vaccine? Is it because of medical? Do not. No. Remind employees of the prohibition against such conduct because he or our facility will end up with discriminatory claims. Can you encourage the vaccination? Of course. That is our primary role, especially in this pandemic of the unvaccinated. We have to encourage vaccination. Although based on the data that we have, all our client facilities, we are doing good. We are at least 92% vaccinated. Okay? Less, of course, those due to medical or religious reasons. Okay? We are doing good. Because national average, only 50%. But in the industry, we're talking about our industry. We are doing good, huh? So consider other incentives. How about giving them an additional vacation day or half day? You see? Or paying them for the time or cost of voluntary vaccinations. Okay, we're going to pay you. Don't worry if you go to Walgreens or whatever it is. But of course, you have to run this with your consultants. Okay? Bonuses though, we don't give bonuses. Can you ask employees about their vaccination status? You have to tread carefully. Okay? Employees, they cannot ask their coworkers. Management can, but you have to tread carefully. We can only do that if we have our policy, our notice, right? And which we do. Because there is mandatory, our policy is mandatory vaccination, right? So management can ask that question. Okay? The refusal to take the vaccine. But any other employees, no, do not ask. You might end up with a case of discrimination. Proof of vaccination status or accommodation request may be a condition of employment in a written offer letter, right? Yeah, because mandatory. So if you have an applicant that applies, okay, are you vaccinated? Yes, okay. Can you provide us a proof? If you cannot provide us, sorry, we cannot hire you because of our policy. But you cannot do this not unless we have the policy in place. And I know it is in place. So this is very important, okay? Maintaining employee privacy. Do not disclose employee names regarding positive cases or vaccination status. So both, okay, confirm and those vaccinated or unvaccinated. Do not disclose in the workplace or even third parties. Now you're getting confused regarding the notice under AB 685. Under AB 685, we have to provide a notice, right? But you don't mention the name of that employee who is confirmed COVID positive. It is only those who are in close contact that you can divulge the name. Because how could you determine contact tracing if you don't tell the employee, hey, you know what? You are exposed to Mr. Joey Tugong. Oh, you really have to. Because based on the schedule, you were working together with him. But the rest, do not inform. You might end up with violation of privacy. Remind employees that they may not ask about another employee's medical status. Why do you refuse to take the vaccine? Do not. Keep all medical records confidential. If they provided you a medical certification, why they cannot take the vaccine and the proof of their vaccination. Remember, I discussed that earlier. That is confidential. Okay? So we have to avoid discrimination, harassment, and retaliation. Remind employees of our policies. Remind employees that masks, vaccination, other are private and protected. See? Remind employees to address any issues with management instead of each other. What did I say? Among coworkers, please do not. If you have any issues or concerns with a coworker, please approach us. Why? Because we are in a position, we have the authority because we have a policy, right? On mandatory vaccination. And of course, the COVID-19 mitigation protocols. And of course, the CPP. Okay? And the INIPP. So this is just a guidance to you. We're almost there, my friends. How do you handle employee complaints? See, I don't just want to confine myself to the ETS. We're giving you the necessary tools for you to have a better way of managing things to avoid lawsuits. Because this is part of the presentation. So, provide employees with names, titles, contact information of management personnel to whom they can complain or raise questions. So, perhaps you want to place to notice any COVID-19 issues. Okay? Please contact or refer to administrator or DSD. Please don't discuss this with your coworkers or any of the management. See? Remember that complaints regarding safe and work conditions is not only within the purview of OSHA but including the National Labor Relations Board or the NLRB under the National Labor Relations Act. If you think NLRA only pertains to union, no. Because concerted activity falls within the ambit of NLRA. So if you have two or more, that is concerted activity, right? And they felt that you have not attended to their complaints, there is unsafe working conditions, and they filed a protest or complaint, they can go OSHA, they can also go to NLRA. See? So when you get all of this information, any report, investigate and promptly address any complaints. Most important, follow up with claimants. Okay? Very important. It does not end there. So now, we're almost the home run, the finishing line. Okay? Upcoming litigation. And so November 30, all client facilities, again, sponsored by Dave Lipa. We are going to have that. Of course, we're going to have that, right? The food. The speakers will talk about preventing or avoiding litigation pertaining to the COVID-19. And so this is part of it. I just want to share it with you. In order to avoid litigation, OSHA claims, remember, serious and willful violations. What is serious and willful violations? There is already apparent, obvious, okay? You don't provide PPE, and then you don't have these barriers for red and yellow zones, okay? You know, anything that you don't do as required by law, that is serious and willful. And the damages, the penalty is treble. Meaning if it's 5,000, they can come up with 15,000, 20, or 25,000. Failure to maintain a workplace, failure to comply with this ETS, they can file a claim. If we fail to report it to workers' comp, if it is a serious injury, we end up with a penalty. Okay? Complications after mandatory vaccinations. They ended up in the hospital perhaps. Okay? So, there is a potential for litigation. So, what we do, friends, inform Elizabeth and Elma, we will report it to workers' comp and that would cover us. And by the way, we have 2 employees, unfortunately, that died of COVID-19 and make it 3. Okay? Confidential. I will not say it. Okay? Upcoming litigation, failure to provide proper COVID-19 benefits. See? The CSPSL, benefits, paid sick leave, etc. Failure to reimburse employees for those who work at home. So, failure to provide COVID benefits after separation. You see? If an employee, you terminate, okay, or voluntarily resign, give them the COBRA notice. Failure to provide EDD information. Okay? So, what does it mean? You know? If they file fraudulent claim, if I were you, contest. File a fraud, okay? Or if EDD, they applied and they said COVID-19 and then you did not respond when you know that it's not COVID-19, right? And you end up with a possible litigation, and this employee will move further, perhaps apply for workers' comp, and they can use that as an evidence. Look, I filed for EDD, they did not even contest. Meaning, I had COVID. See, these are small things, but it could become bigger. Now, this one is very important. Don't wield your authority, indiscriminately. Okay, use it judiciously. Failure to provide work to unvaccinated employees. Okay? See if you can provide reasonable accommodation. Be compassionate. We know that we have a mandatory policy, but we have to thread carefully in interactive discussion. Okay? Do not divulge their names. Improperly refusing to allow remote work. There are employees who would like to work remotely. Okay? They don't outright say no. Tell them the reason why. Improper release of confidential medical information. See? You can only release this to the proper agencies, not to anyone. There could be a case of harassment and discrimination, which I already discussed it with you. For those who refuse to wear the mask. For those who wear the mask. See? Why did I say those who wear the mask? Because vaccinated employees, that is the right if they want to wear their mask, right? And then you start to taunt, okay? Or make fun of it. You're already vaccinated, you're overreacting. Why are you wearing the mask? Outdoor.
That's ilang hours ang nursing hours.
Yeah, well, what is that? The nursing hours. Can you kindly mute? Okay. And then wrongful termination based upon COVID-19 cases or vaccination status. My friend, I strongly suggest or respectfully suggest if an employee is COVID-related, okay, or was COVID positive, and you're going to terminate this employee, okay, by reason of other than perhaps the COVID, please run it with our office because he or she might claim that it was discriminatory. Okay, please run it with us. Protecting against future COVID-19 claims, C, okay, follow all ETS and executive order requirements issued by Governor Newsom. Again, conduct training and maintain your COVID-19 prevention plan. I will roll this out, send this out. Elizabeth and Elma will send you these three, CPP, INIPP, related to COVID, and AB65, the notice to all employees. Why? Because if OSHA will come in, can I get a sample copy of your notice? This building, based on our records, had COVID cases. In fact, it was a major breakthrough cases, 20 or more. Did you notify the employees? Now, if you don't have this in writing, end up with statutory or regulatory violation. Big time, $5,000. Okay? And audit the workplace to be sure employees are following your requirements. Communicate with your workers' comp carrier regarding, forget about it, anything pertaining to workers' comp, we will take care of it, okay? Regarding your insurance provider, okay, this pertains to COBRA. So if you terminate your employees, okay, of course, COBRA notice. Again, to protect future COVID-19 cases. My friends, I am sharing this with you because risk management is to avoid, prevent, eliminate any forms of risk, right? So we don't want you to end up with a liability. My friends, very important, just like HIPAA, protect all confidential medical information. This is in the ETS, Emergency Temporary Standards. Avoid workplace discussion of COVID-19 cases or vaccination status. Remember, not only COVID cases, vaccine, but including masking. Okay? Train managers and employees in this regard. Maintain secure files for medical information. You have to maintain it. Don't just leave it, open in your table. Secure it. So you have to remind employees about harassment, discrimination. You see? Do not taunt. Okay? Do not joke. Do not banter. Do not accuse. Or don't be accusatory of people who refuse to take the vaccine, or those who take the vaccine, or those who refuse to take the mask, or those who took the mask, take their mask even though they are vaccinated. Tell them, please do not. Otherwise, we end up with a problem, and then develop complaint procedures. So if they have any issues, don't discuss it with other employees. Run it with us. Reimburse employees for all remote work expenses. So if you have employees that in the past you did, my friends, do it now. Check whether we have paid or there was shortage in payment. Otherwise, they can go to the labor commissioner. And then, of course, all the mandatory COVID-19 sick pay and other leave benefits, please audit them. Go back to the past. If we need to retro it. In our office, we have helped your buildings some of the main, payroll officers, they referred to us. Some of your DSD referred to us with Elizabeth or Elma. Say, pay. Oh, what is $500? What is $300? Okay? If it is really due and goes way back. Remember, CSPSL goes way back January 1 of 2021. So you must, the employee perhaps already forgot whether they knew it or not. And when you did an audit, pay. And they will be surprised. How come? No, because we did an audit and you deserve it and we reinstated back your sick leave benefits, assuming that is the situation. So if they want to remote work, work remotely, which is a reasonable accommodation, don't outwardly say no. Evaluate first. Look, we'll get back to you and see if it's feasible for you to work at home. So documentation is very important to all non-discriminatory business reasons for termination and layoffs. Always document. Okay? We will not go into this anymore. I provided you all the materials. This is just a recap. Okay? The 5 key changes in the modified ETS. So I will just skip this and I will go to the last 2 slides. I did this intentionally, but not to discuss. So that it will just give you, boom, what are the 5 key changes. Okay, we're almost there. Let's go to the final notes. Last 2 pages, last 2 slides. 12.7. Employers should remind employees that medical decisions, including vaccination status, are confidential and private. I guess this is your first time to hear about this. This is confidential. Discourage discussion of vaccination status in the workplace. And remind employees that harassment, discrimination, or retaliation against others based upon their vaccination status or face covering preference is prohibited. You see? So you cannot post. I was also stupid in the past. I said, for us to encourage others to take the vaccine, post those who took the vaccine. My friends, we cannot do that. By the way, under ETS. Cannot. Those who are fully vaccinated, you list down. And those who are unvaccinated, you cannot do that. Okay? Now, face coverings. There are face coverings which are not surgical masks, right? And they have this flag of the Philippines, flag of United States, or LGBTQ, anti-Asian racism. My friends, that is their preference. Do not discriminate them. Okay? Employers are mandated to update their COVID-19 response plan to their INIPP. Already discussed this. After the COVID-19 crisis evolves, so will the regulations. Employers will need to effectively respond to provide a safe and effective workforce and avoid possible penalties for failing to do so. Crisis has ended, and then it doesn't mean that we are going to rest our hands. We will throw everything what we had in the past, the COVID, my friends. There must be a paper trail, secure, protect it, because moving forward, we will end up with litigations, with class action lawsuits. All those, these lawyers, they will be out there soliciting. Okay, either for workers' comp or for residents, family members that died in their building. That's why in our earlier COVID, webinar, Marybeth said, please audit all of your residents with COVID cases. Because they could be a possible, that died rather, okay, for potential COVID-related lawsuit. For employees that died as a result of the COVID, okay, may their soul rest in peace. No problem. Because under workers' comp, they cannot file a lawsuit, right? Because that is the bargain. Cannot file a civil lawsuit. But workers' comp will take care of them. $10,000 for funeral benefits. And if they have children under 18 years old, their dependents, they will receive benefits, okay, on a monthly basis until they reach the age of 18 years. Workers' comp will take care. They cannot file a lawsuit, okay? And this is the last. Foster positive morale. Administrators and department heads, very important. We have to thank our employees for their commitment in the difficult year. They are the frontliners. They are human beings with minds, with emotions. And they have perhaps psychological, impact on their well-being. Please take care of them. Okay? They are not, you know, an object subject to do this, do this, do that. We have to understand them also. Encourage employees to support each other as a team. Let's work as a team. It's not good where each employee is doing something that the other doesn't know. Everyone should get involved, work as a team, foster that kind of values or part of our corporate philosophy that we work as a team. Okay? And it all starts with you as a supervisor. You have to be inclusive, not exclusive. You only choose people to be within your orbit. Take care of your employees. Remind employees that this has been a stressful and challenging time. Okay? And so, interactive discussions comes into play. We understand if employees refuse to get vaccinated. We understand if employees refuse to work for fear of the COVID. We understand if their employees refuse to wear the mask. Do not discriminate them. Interactive discussion. Talk to them, okay, before you do anything else. Offer mental health and support services. You know what is the EAP? EAP means Employee Assistance Program. This is the last page of your employee handbook. Throughout my 21 years in this company, I never had experience where our administrator provided emergency assistance program. Emergency assistance program meaning if an employee has mental difficulties, psychological difficulties, it could be due to drugs also. We're not only talking about COVID. It could be drugs, it could be alcoholism, and they have no leave of absences that will protect their job, and you know that they are a good employee. It's just that they cannot grapple with their inner demons as an alcoholic or a drug addict. Okay? You can provide the emergency assistance program. Their job is protected. And you initiate it. Look in the community. What support services that can be provided to this employee? You see? How I wish that one day somehow you're going to use this particular provision, Employee Assistance Program. See? Community. This is community-based. Encourage employees to come forward with any issues. Look, if an employee refuses to work, okay, because of fear, I would rather not terminate. Just place her on, indefinite leave of absence. Indefinite leave of absence. At least, you end up no case, right? Because if you terminate, they got a copy, wrongful terminate, you might end up with problems. Remember, if it ends in the desk of Jim Balls, our labor lawyer, 5,000 is automatic in terms of a nuisance settlement. On an average is 15,000. Jim Ball cents is made of gold. He charges $650 an hour. You see? So we would rather just, don't do anything. Now, when the pandemic is done, you're still considered to be an employee. Please return. But if the employee is bad, okay? Bad. And then, of course, but we have to put all our ducks in the row. Remind employees to be gentle with themselves and each other. Remember that reopening is not a celebration for everyone. Remember, we have opened up the economy last June 15. It is not a cause of celebration. Look where we are right now because of the Delta variant. So that ends my presentation. Thank you so much for your time. And then, please don't forget your sign-in sheet. Okay? You don't have to give it to us. But this is in anticipation of a potential litigation in the future. We may never know. Or an inspection. Did you roll out your ETS? Well, Mr. Joey Tugong, here's a copy of the presentation. And here's a copy of our model program. Already you filled up. And here is the attendance, the sign-in sheet. These are the proofs. Okay? Please do that. And we are done. Thank you so much for your time. And enjoy your lunch. I miss you all. I love you all. Please take care of yourselves. For those who are unvaccinated, please take your vaccine because of the Delta variant. All data shows that this variant is the worst among them. Okay? Thank you so much, and that's it. Since I'm done.